Good afternoon, everyone. Welcome to our knowledge sharing webinar, Hong Kong Competition Ordinance Developments and Considerations. I'm Janice from LexisNexis, the moderator for the webinar today. Here are some housekeeping matters before we start. Whenever you sign in, please remember to stay on mute to prevent any disruption to the speakers during the presentation. If you have any questions, please feel free to private message LexisNexis Hong Kong or drop your questions directly to the chat box for us to read them out and address them at the end of the webinar. So without further ado, we are very honored to have two distinguished speakers with us today. The first distinguished speaker is Mr. Marcus Pollard, a competition counsel from Linklaters. For our second speaker, we have Mr. Carter Chim from Dennis Chang's Chambers. As we have quite a number of legal practitioners joining the knowledge sharing webinar today, I would like to give you a brief introduction of today's speakers. Let me first introduce you to Mr. Pollard. Mr. Pollard has a range of experience based on his work in both Europe and Asia, as well as being a former in-house lawyer at the Hong Kong Competition Commission. His focus is assisting clients under investigation under the Hong Kong Competition Ordinance. He has advised a respondent in the first enforcement proceedings before the Hong Kong Competition Tribunal and Court of Appeal, multinational clients on ongoing confidential cartel, RPM, and abuse of dominance investigations under the Hong Kong Competition Ordinance. Prior to moving to Asia, Mr. Pollard was based in Brussels and worked on a range of global cartel and antitrust matters, including investigations with complex remedy or commitment processes in the EU and China, leniency applications, and multinational litigation. Mr. Pollard is recognized among the most highly regarded practitioners and celebrated as a phenomenal competition lawyer by Who's Who's Legal Competition 2020 Future Leaders. He has also been listed as a rising star in competition and antitrust in the expert guides for 2 consecutive years and named a next generation lawyer by the Legal 500. Thank you very much for joining our webinar today, Mr. Pollard. I would also like to introduce you to Mr. Chim, who is our second speaker today. Mr. Chim was called to the Hong Kong Bar in 2012 and has established a solid practice specializing in competition law, advising clients in both the public and private sectors. In 2015 to 2016, he was appointed as a legal counsel to the Competition Commission Hong Kong, where he helped the Commission finalize its guidelines, drafted policy documents, and acted as case manager of the Commission's first enforcement case. Equally adept at representing the opposing party, Mr. Chim was subsequently instructed as a defense counsel in the Commission's second enforcement action. Shortly after the Competition Ordinance was enacted in June 2012, Mr. Chim began his employment as a member of the Hong Kong Bar Association's Special Committee on Competition Law, a role he has remained in ever since. In 2016 to 2019, he assumed the role of professional consultant of the Faculty of Law of the Chinese University of Hong Kong, teaching competition law. Currently, he also serves as a non-governmental advisor to the International Competition Network, the only global body devoted exclusively to competition law enforcement with members representing national and multinational competition authorities. Mr. Chim is the sole author of the Butterworth's Hong Kong Competition Law Handbook 2nd edition, which was released in September 2020. Thank you very much for joining our webinar today, Mr. Chim. For today's webinar, we will start off with Mr. Pollard's presentation, followed by Mr. Chim's presentation. Towards the end of today's webinar, we will have a Q&A session, which we will open the floor to you all for further discussion. May I now pass the floor to Mr. Pollard and Mr. Chim to share with us their insights.
Let's talk about competitions history and recent history. Today we have a bit of a whistle-stop tour over recent practices in Hong Kong. So we'll continue at quite a pace. We will look at things quite practically from our experience of investigations and on litigation in the Competition Tribunal that we have worked on, and we'll cover 4 main elements: recent enforcement trends, We'll look at how penalties are developing in Hong Kong and the direction of travel there. We will look at leniency policy and the reasons for why it was revised this year. And then we'll end looking at alternatives to leniency, which is cooperation and settlement. So if we start with the next slide, which is a 5-year summary of what has happened in Hong Kong under the Competition Ordinance. There's a few statistics there, I think, which would be quite interesting for everyone to focus their mind. The Commission is incredibly focused, or a lot of their input, let's put it that way, is from complaints. We'll touch on it later on in the context of leniency, but Hong Kong is quite rare that so many complaints are being made and that complaints are the focus of their investigations. But as you can see, they have a huge amount of complaints made and only a small amount of those, around 20%, make it to the investigation stage. And even a smaller amount of those actually would lead to an enforcement outcome. So what you see in public in terms of decisions or cases in the tribunal, or you see their administrative decisions, those are only a very small part of the Commission's work, and actually the scope and number and type of investigations that are ongoing at any one particular point in time. What you will see, though, of course, is that most of the Commission's output and its investigations are in relation to the first conduct rule. So they're looking at agreements or concerted practices at a horizontal level, so cartels and other cooperative arrangements, and also other elements such as vertical arrangements and in particular resale price maintenance, although there is no public case of an investigation on that at the moment. The first 4 cases that were taken to the tribunal are flagged up on the slide with some of the details there. The first in relation to alleged bid rigging in relation to a tender by the YWCA, and which I worked on for a client, and the other 3 are relating to decorating and building renovation in public housing estate, which Carter worked on. All of these are have a very common feature. They are very straightforward in terms of fact pattern. The legal issues arising out of them are complex because these are first cases. So the legal issues that we've had to explore in those cases have been starting from first principles and arguing with the Commission and at the tribunal on those points. But the focus has very much been on what the Commission views to be clear-cut cartel conduct. The YWCA cartel is on appeal to the Court of Appeal, and the ONTAT cartel, one party, has also appealed to the Court of Appeal. So we will have to see how those cases eventually develop. Another, though, some of the statistics that I think focus the mind is, firstly, you'll see 23 out of 24 respondents are found liable. Is that a surprise? Is that because the Commission has done a very good job? Well, I'll leave that for you to reach a judgment on. But what I would say, of course, these are first cases, and it is not surprising that that the Commission wins those cases, given the limited fact pattern and the relative simple cases that they have taken or decided to take to the tribunal. The 2 factors I think that are of note. One is in terms of individual liability. So from my perspective, there is still a legal question, open question, about whether natural persons, individuals, are meant to be fined under the Competition Ordinance. You won't find any discussion of that in the legislative stage during the Competition Bill. And it's only recently that the Competition Commission has taken individuals to the tribunal and is trying to seek that they should pay pecuniary penalties or have disqualification orders, or in some cases, both. That prospect of individual liability focuses the mind of employees involved, certainly. It also should make directors of companies a little more alert, because they potentially could be a target of enforcement outcome. Second point, I think, is, and it's a point that Carter can touch on later when it comes to penalties, is around the level of fines. So far, there's only been the level of fines has been very limited. So total fines of no more than 4 million Hong Kong dollars, which means for any single of the cartel participants have been fined, the fine has been very limited, and in only one case, a fine of more than 1 million. So the absolute number is very low comparatively to overseas precedents, which raises the question, well, is there going to be a deterrent factor for large multinationals, for example, if the fines are so low? However, in those decorating cases, the fines actually reached the 10% statutory cap. So it showed that these fines could be very significant. In Europe, there is a 10% cap, for example, and we very rarely get anywhere near the 10%. But here in Hong Kong, it seems to be we are hitting that threshold very quickly. If we move on to the next slide of what has happened in what we call a bumpy year. So it seems that when the Competition Commission works at home, they are more productive than in previous years. So there has been a strange converse relationship between productivity and working at home for the Commission. And these are some of the points that has happened this year. The first case this year that's taken to the tribunal in relation to textbook publishers who were accused of and will be facing trial sometime next year or the year after, in relation to a alleged cartel that has been running for nearly seven or 8 years before the ordinance came into force, which of course was legal, and afterwards, which is being claimed by the Commission to be illegal.
From 2011.
2011, yeah, exactly. So that I'll talk about in a moment about why that's an important case. The Commission also, in line with every other authority in the world, came out with guidance in relation to cooperation around COVID situation and offered an accelerated process to discuss cooperation. They also, though, gave a warning to market participants to say, particularly for those that are bidding for funds from the government's anti-epidemic fund, that there should be no collusion around bidding for those funds. The commitments just in relation to online booking, online travel agents, I'll come on to in a moment. Same with the Seaport Alliance. Commission has a new chairperson. Samuel Chan has been at the Commission for a number of years, so he's not entirely new. He's been chair of the Enforcement Committee, so has already been very involved in a number of ongoing investigations. So we will see whether in the next year or so whether his style and of leading the agency is very different to his predecessor, Anna Wu. And finally, of course, Brent Snyder, who came to Hong Kong only less than 3 years ago, has decided to step down and return to the United States. And his successor has yet to be appointed. But again, we will see, I think, in early new year, the direction of the new CEO when he or she is appointed, and the direction they will take. So just to unpack a couple of those cases onto the next slide, please. In relation to the Ocean Park IT bid rigging case, as simple facts as you can imagine, actually it seemed to be a very simple one-off WhatsApp and email exchange. But the most interesting point for us as practitioners is to note that this was the first successful leniency application. And what I mean by successful is that it's the first case taken to the tribunal on the basis of a leniency application by one of the parties involved, one of the bidders involved. It's also novel because the Commission decided instead of taking all of the parties to the tribunal, they would actually issue an infringement notice. Now, the Commission has said they ordinarily wouldn't do that for cartels, and actually for cartels, the tribunal should be the route. So that seemed to be a bit of a novelty. And only last week, the penalty was agreed by one of the bidders by consent order. And as you can see, they agreed to pay a penalty of $37,000. I imagine the Commission's legal costs for that case vastly exceeded 37,000, particularly as I understand they involved London QC for such a case. Again, deterrent question starts to raise if you think that fine is very low. Second novelty is about the textbook cartel or alleged cartel. The novelty here is actually there is an action against a parent company. My understanding of the fact pattern is that actually the parent company might have been directly involved at some point. So it is not a pure parental liability where essentially liability is only because of their fact of being a parent. Here, as I understand it, the Commission is alleging that the parent was also involved or had some active role. But we will see how that plays out in the tribunal as it seems to be a contested case. And Carter will no doubt be steering the parties, hopefully to a successful outcome on that case, but we'll see. The other novelties this year have been around commitments. If we move on to the next slide. And these are, by their nature, they are more complicated and more difficult theories of harm for the Commission to pursue. And this has led to commitments as an outcome, because the parties in that case were willing to solve the case or solve the alleged concerns through commitments rather than having a contested fight in the tribunal or forcing the Commission to litigate. The first is in relation to online travel agencies. We acted for a party in this case and an involved party in this case. And as you can see there, the Commission was alleging that the most favored nation clauses between online travel agencies and hotels in Hong Kong led to a chilling of competition, essentially freezing the terms and conditions that were available for consumers. It's not a new topic. It's actually been discussed and has been investigated in Europe, in a number of jurisdictions in Europe for about 10 years. So it's not new. The theory is not new. It's just it seemed to be hadn't been looked into Hong Kong as yet. Anyway, the parties listed there were willing to solve through commitments and make changes to their contracts. Whether there were some parties saying that the commitments did not go as far as should have occurred, but we will see in the future when those commitments are up for renewal whether they will continue or whether they would be expanded. Secondly, one of the more high-profile investigations has been in relation to the Seaport Alliance, which is a very close cooperative alliance between 4 of the 5 port operators in Hong Kong. The Commission was very concerned with this cooperation because it was aligning or certainly exchanging incredibly sensitive price capacity information and combining that with the very high combined market share of all the parties involved. So this was an investigation that's been going on for at least 3 years, around 3 years, but it has been solved through commitments, and the parties, the alliance and the port operators have made commitments, including price caps, minimum service guarantees. Those, I have to say, are behavioral commitments, usually very difficult to monitor. So we will see, I think, in the next couple of years, the success of those commitments or not, and the extent to which they are properly being operated by those parties that were under investigation. Anyway, that's a very quick canter through what has happened in the past year in terms of investigations, and I'll leave it to Carter to talk through some of the dollars and cents related to penalties.
So thank you, Marcus. It's a very good summary of what happened in 2020. So what I'm going to talk about is the methodology, or the steps that the tribunal will take in calculating the penalties that it would impose. I will talk more about the background and actually how the tribunal came up with the four-step approach that I'm going to explain. So the four-step approach now adopted by the tribunal is based on the seven-step approach proposed by the Commission in the first place. The Commission said, well, let's look at the EU-UK approach, because after all, we copied our first conduct rule and second conduct rule from the EU jurisprudence. But curiously, the penalty clause in the ordinance is actually copied from Australia. So we compared both jurisdictions and find that, well, perhaps this seven-step approach is not appropriate in Hong Kong. So the seven-step approach proposed by the Commission starts with determining a base penalty. So the base penalty is based on the revenue that the undertakings may derive from the conduct that constitute the contravention. So let's say if an undertaking is found guilty of a contravention of the first conduct rule, and it derived, let's say, 10 million from as revenue from the conduct in question, then that would be the starting point. Then, well, the Commission said we should then apply a percentage to this revenue. Let's say 22%, 23% of the revenue as the base penalty. So how did they come up with the numbers, the magic number, whether it should be 21, 22, 23? It would be very arbitrary. There's no magic number. There's no formula at all. So that's the first step that they proposed. Then they said, well, we should then look at the background, the circumstances in which the conduct took place. And eventually we look at other aggravating or mitigating factors, such as those set out in step 3 to 5. And then afterwards, they would say, well, we can then apply the statutory cap in the legislation, which is 10% of the local turnover. And only afterwards, at the very last step, we apply the cooperation reduction, which we will cover later today. So, next slide, please. So when we look at this seven-step approach proposed by the Commission, we said, well, it wasn't right because, well, it appeared to be transparent. It appears to be predictable as alleged by the Commission. But if we look at the Australian jurisprudence, the highest court there, the High Court of Australia, clearly said it was only false transparency or false predictability, mainly because, as I said earlier, well, you start with an arbitrary number, whether it should be 22% of your revenue or 24, 25, well, it is arbitrary in the first place. Secondly, when you have all the steps there, 7 steps there, well, for each step, it is not a logical conclusion for the next step. So it shouldn't be a linear process for calculating the penalty. Well, importantly, in each of the steps, you need to exercise a judgment call. Let's say if you start with 25% of your revenue as the first step, then in the second step, you may add 1 million to that number. And then in the first step, you deduct, let's say 50,000 in your third step. And then fourth step, you add 2 million again, and so on. Well, for each of the steps, you need to exercise a judgment call. And that means it would bring about a risk of miscalculation in each of the steps. So the risk of coming up with a wrong number will only increase exponentially. So, well, it doesn't make sense to have a 7-step approach as proposed by the Commission. And at the end, the High Court of Australia said, well, the overarching concern is whether the penalty is proportionate to the criminality of the conduct. So, well, why don't we just look at proportionality as the only concern? So that's why the High Court of Australia said, well, sorry, the so-called 7-step approach is erroneous. It's wrong in principle. So at the end, next slide, please. So the tribunal sort of adopt a middle way house in the sense that, well, 7-step is too much, but well, perhaps let's reduce it into 4 steps. So we keep the first step. We still need to determine the base amount by applying a ratio, a percentage, to the revenue that the undertaking derived from the conduct in question. So the so-called second step to the 5th step in the 7-step approach proposed by the Commission have been condensed into one single step under the tribunal's decision. And only afterwards, we apply the statutory cap, the 10% of local turnover cap, and then we apply the cooperation reduction, the details of which will be explained later today. So that's how the Commission has come up with the 4-step approach right now, which will be applied in the first case and subsequent cases. So now we will move on to the leniency policy, which has been revised by the Commission recently, last year.
Thanks, Carter. So as I said at the beginning, actually, in other jurisdictions, take EU, 90% of cases in the European, 90% of cartel cases in Europe begin as a result of leniency applications from some of the cartel members who want to self-report. Hong Kong has had a leniency policy right from day one in December 2015. But there was a view, I think, taken internally by the Commission that it wasn't working, that they weren't getting enough leniency applications. Now, there's a question there, whether it's the policy that wasn't working, or was it simply that people weren't reporting for other reasons? And again, it may be a bit of both, but the Commission thought it was the policy. So the Commission, therefore, this year has adopted a new leniency policy. I'll talk about the individuals element in a moment, but essentially their objective with the revised policy is to increase the effectiveness of it and to encourage more people to apply. The big difference, and really one that the Commission saw to make would make the difference, is that in the old policy, you would still be required to make an admission of a contravention in the tribunal. So you essentially, even though you got immunity from a penalty, you would still have to have a declaration that you had broken the law, which would then allow third parties to sue you for damages in a follow-on claim. That element has been removed under the revised policy. So effectively, if you are a leniency applicant and you are number one in the queue and you comply with all of the conditions that the Commission imposes on you, you are fully protected from any financial consequences, which is meant to give a much stronger incentive. Now, the old policy led to, as I said earlier, the first case, the Quanta case, which involved a leniency application. There are other cases we know about where there have been leniency applications that were not successful for various reasons, and we may learn about that in due course. But in the same way that the Commission wanted to encourage companies to report, the Commission also adopted for the first time an individual leniency policy. Now, under the company leniency policy, individuals get the benefit, so individual employees. If the company makes an application, it's an umbrella that can cover all of the employees. But the Commission's policy, not only in leniency, but generally in its enforcement now, is to try to turn employees against their employer and to try to divide the two, because they hope that employees will be weaker, won't have lawyers, and would be more keen to protect themselves and report and give evidence to the Commission. That is, of course, a risk for businesses, and whether that actually would succeed in Hong Kong, I have some questions about that, because I don't think employees are as easily led down the path of temptation that the Commission has set for it. If we move to the next slide on individuals. So now the Commission makes it very clear that if you are an employee and you were involved in a cartel, you can go in and report in your own name, and you will actually be protected in your own name. This protects you as an individual from any pecuniary penalty, and protects you from a director's disqualification order, for example. Of course, it doesn't mean that your company is protected. So effectively, the Commission may want to use you, the employee, the protected employee, to turn against the company and serve as evidence against the company. That, of course, is a significant area of uncertainty for current employees, how that would behave. If you're a former employee, then maybe you have no relationship with the company any longer and you're willing to report. But of course, what the Commission doesn't mention in all of this is reputational impact. Your photo, your name appearing in Apple Daily when you have to go to trial, your name appearing in a judgment of the court, that's not mentioned in the policy either. So employees would be well advised to have a second look at some of those principles. The temptation of immunity may be one factor, but you have to balance that with a whole other set of considerations. And of course, leniency, when we talk about leniency here, we're talking about immunity essentially. So that is complete immunity from pecuniary penalty. And what Carter will now talk about is something less than immunity. Next slide.
So, well, of course, usually when people come to us for legal advice, and the very first thing that you need to do is to look at whether there's a good chance to apply for leniency, because time is of the essence. You have to be the first undertaking or individuals to report the case to the Commission. But even if somehow, for some reason, leniency is no longer available, let's say someone is faster than you, or let's say the Commission has already done adequate investigation and so on. Well, it doesn't mean that that's the end of the story. You need to start preparing for your defense, because you still need to consider whether you should participate in a cooperation regime that was set up by the Commission last year. So even if your client is not able to benefit from the leniency policy, well, under this new cooperation policy, you may still try to obtain a discount from the penalty that will be imposed on your client. So how do we do that? Well, first of all, always bear in mind that only undertakings can benefit from this new policy. Individuals can't. So it is different from the leniency policy. That's the first point. And secondly, well, on top of the, other than the discounts that would be imposed on the or applied to the penalty, well, basically, what you need to do in terms of cooperation, which will be largely the same as what you need to do under the leniency policy. You have to fully cooperate with the Commission. You have to give them necessary information, documents, or even testify in the tribunal and so on. So there would be a cooperation agreement that you need to sign and enter into. And eventually, there would be an agreed factual summary that you need to commit to. And based on the cooperation agreement and the factual summary that you agreed to, your client and the commission would jointly apply for a consent order. The consent order would include some standard terms that I am going to talk about, please, in the next slide, actually. So the consent order under Rule 39 of the Competition Tribunal rules would include 3 key standard terms. So first of all, you would have to agree that you would pay a pecuniary penalty on the basis of a joint recommendation by the undertaking and the commission. So how it will be done, it remains to be seen. What I would imagine is that you would need to apply the recent judgment of the tribunal in W. Hing, the 4-step approach that we just covered, and try to come up with an estimate. Then you would try to argue that, well, I should be in Band 1 or Band 2 or Band 3 in the cooperation regime. Band 1 means you are the first undertaking who goes to the commission and say, well, I would like to cooperate with you. In that case, if you are in Band 1, you will be able to obtain a 50% discount. Well, if you are not the first one who proposed to cooperate with the commission, then you may fall into Band 2 or Band 3. Well, whether you would fall into Band 2 or Band 3, again, the commission didn't really explain. They only said we would determine on a case-by-case basis. But you can imagine that if you are the second or third undertaking who offer cooperation, there will be a higher chance that you would be put into Band 2. But if you are like the 4th one, the 5th one, the contribution that you can make would be less, obviously. The values of your evidence would be lower than those who goes to the commission earlier than you. In those circumstances, it is more likely that you would only be put in Band 3, which means you may only be able to obtain a 25% discount. So, so that's how you come up with an estimate, which eventually becomes the joint recommendation by the undertaking and the commission. Well, after coming up with this joint recommendation, parties would make a joint application to the tribunal in the form of a consent order. And the consent order would include an agreed factual summary. In other words, you have to admit that you contravened the law, the first conduct rule, which means, well, you will be susceptible to some follow-on action after the public enforcement action comes to an end. So this is different from the leniency policy. So as Marcus explained, if you successfully applied for leniency, you need not worry about all those private damages claim in the form of follow-on action. But if you can't benefit from the leniency policy and you choose to benefit from this cooperation policy, well, yes, you may obtain a discount from the penalty being imposed on you, but you need to bear in mind that your client would then be subject to the risk of private damages claim as a follow-on action. At the same time, you will have to agree that I would pay cost to the commission, the cost of proceedings against the undertakings, the cost of preparing this consent order, and so on. So this part of the cost need to be borne in mind as well. So basically, that's the how the cooperation policy is like. So far, I'm not aware of any cases in which this cooperation policy is being invoked or applied. So we'll have to wait and see.
I think one point to make there on here actually is to say that I think in all the cases so far that have reached the penalty stage, the Commission's legal costs exceed the penalty.
Oh, yes.
So even though your penalty exposure may be 37,000 Hong Kong dollars, your portion of the cost may be several million. So your counterparty is not a cheap user of legal services. They pay a lot for legal services from London QC, for example, and that means you're going to end up paying for it.
Yeah. So that's a good point, because in the second case, the W. Hing case, the Commission engaged a London Silk, a local Silk, and a local junior, and they applied for a certificate for free counsel. And at the end, Mr. Justice Goffey Lam said, well, that's too much. I will only give you a certificate for 2 counsel, covering 1 senior counsel and 1 local junior. But perhaps the penalty, or the penalty is far below the cost incurred by the Commission. The Commission actually applied for leave to appeal, seeking a certificate for free counsel from the Court of Appeal. But as far as I understand, that application was late and was rejected by the tribunal. Yeah.
So I think we've reached the end of what we had planned to speak to you about today, but we're very happy to take questions from anybody in the audience. I see one has already popped up, but let me try to read it.
Hello, everyone. I'm really sorry. I just have some technical issue just now. May I check if everyone can hear me clearly now?
Yes, we can hear you.
Yes.
Hello. Yeah, thank you very much. Thank you very much for your very insightful sharing, Mr. Pollard and Mr. Chim. So let us proceed to the Q&A section. If you have any questions, please feel free to private message LexisNexis Hong Kong, or drop your questions directly to the chat box for us to read them out at the end and address them at the Q&A section. Just see that there's one question in the chat box, so may I just read them out?
Yeah. Okay, so the question essentially is, with COVID-19, what tips can we, or what advice would we give in relation to cooperation, and particularly in relation to cooperation around applications or those participating in the anti-epidemic subsidy programs? I think the basic principle is that the law hasn't changed. So the same things we would have said a year ago, when COVID wasn't even a term we'd ever heard of, nothing has really changed in that sense. So in terms of bid rigging or price fixing, all of those elements stay the same, that you as competitors should be deciding for yourself what to do, how to price, what funds to apply for. All of those things remain the same. Of course, there may be in this setting a justification for you to work closer with a competitor on a particular topic, but working closely together doesn't mean fixing prices, doesn't mean bid rigging. So it's a grey line, but COVID isn't going to be an answer to a cartel. If you want to cooperate, there are ways you can do that. It needs to be justified, it needs to be limited in scope, and it ideally shouldn't actually impact the price that you are charging the consumer in the end.
And on top of that, and I totally agree with Marcus that, well, COVID hasn't changed the law. But on top of that, the Commission has introduced a new mechanism under which you may ask them questions or ask them for some preliminary views on your proposed cooperation. Before COVID, if you wish to ask for advice or preliminary views from the Commission, you need to pay. You need to apply for a decision under Section 9 or Section 15 of the Competition Ordinance. But now it is free. You may make use of that mechanism and ask for some preliminary views on your proposed cooperation. And if they give you a green light, then it will be safe.
Yeah. So we actually, that's a good point. I mean, we have advised a client in that free process, as Carter puts it, but there's no such thing as a free lunch, and it certainly comes with a lot of information requirements, that effectively you are volunteering a lot of information about what you want to do, what you will do, etc. which of course has to be balanced again against of, well, do I really need to do this? So the Commission's got a process. It's not that easy to get through, but certainly it's better than nothing. That's for sure. Yeah. Do we have any other questions?
Thank you very much. There's another question, so I'll just read them out. In comparing with the competition ordinance in other jurisdictions, are there any improvement for the competition ordinance in Hong Kong that you may want to suggest? Or
good question. Well, the improvements, I think, is an interesting topic for us, because but I mean, there are two elements I think that are quite unusual, or maybe policymakers need to think about. One is merger control. Hong Kong doesn't have a merger control, so are there market structures that are being created that are leading to other problems in the economy? Open question, that I think. Secondly, it would be standalone private actions. So at the moment, the only way a victim of a cartel can get any damages or any compensation is to complain to the Commission, hope that the Commission takes a case, hope that the Commission wins its case, and the tribunal issues a judgment. If you had standalone actions, you could immediately, as a victim, go to court and seek redress there without having to go through the Commission route.
Yeah, I would add two more items on the list. The first one is the blanket exemption for statutory bodies. Hong Kong is largely a free economy, and usually if there's any distortion of competition, it can be attributed to some statutory bodies here in Hong Kong, and I'm not going to name a few of them, but well, now the ordinance provides a blanket exemption to those statutory body, which is unusual in other jurisdictions. The other item on the list would be the warning notice regime. Again, it was borrowed from the Canadians. So if the conduct involved is not regarded as one of those anti-competitive conduct, the Commission can't bring them to the tribunal directly. Instead, they need to issue a warning notice telling them, oh, I noticed you did this and that, you need to stop by a particular date, otherwise we will bring you to the court, and so on. Well, and if you comply with the warning notice, then that's the end of the case. Well, it significantly dilutes the effectiveness, especially the deterrence effect of the ordinance, and I think perhaps we should review it as well.
thank you very much. So towards the end of today's webinar, I would like to share with you that we have provided a 10% off on the Butterworth's Hong Kong Competition Law Handbook, 2nd edition, for the attendees today for today's seminar. As Ms. Chim, you are the sole author of this book. May I invite you to say a few words on this book or briefly introduce this book?
It's my honor. Basically, well, the first edition of this book, well, had nothing to do with the actual cases that was pursued by the Commission since 2015. It was published before the full implementation of the ordinance. So the content of the first edition was largely based on the guidelines published by the Commission. So put this way, the first edition was the bone. So the second edition, in the second edition, I give it the flesh by including the most recent updates, what happened in the past 4 years, what the tribunals has done to further elaborate the terms of the competition ordinance, the revisions to the Commission guidelines or policies that have been made in the past few years have been fully explained in the second edition as well. So I hope you have a good read, and I hope you find it helpful.
It's a great Christmas gift for competition lawyers. So yeah.
Thank you.
Yeah. Thank you very much, Mr. Chim.
Thank you.
Thank you very much. Please also feel free for to scan the QR code provided to look for details of this book as well. Also, we are having a 30% off for some selected titles. So again, feel free to scan the QR code for information, more information about that. And finally, we will have a new normal law guide as well. So feel free to scan the QR code for more details. So this is the end of today's webinar. I would like to once again thank you, Mr. Pollard and Mr. Chen, for joining this webinar and for very insightful insights. Also, I would like to also thank all of you for joining this webinar. We are looking forward to seeing you all in the future activities. Thank you very much.
Thanks, everyone.
Thank
Have a good
you.
day.
Good day.
Bye. Bye-bye.
Bye-bye.